Greetings and welcome back. In the last mini lecture, I was talking about the concept of prior restraint or censorship in advance of publication. I talked about how this had a very long history going all the way back to the colonial period where British officials retained the right to engage in censorship in advance of publication. And the result of that was that this has been the most contentious area in the arena of press rights. And the courts have given a very wide latitude for the press. They have made it incredibly difficult for the government to censor the press in advance of publication. Think back to the case that I ended with in the last lecture, the New York Times versus the United States case, or is often referred to as the Pentagon Papers case. Even though in that particular case, the Pentagon Papers was a classified top secret document, the Supreme Court allowed the New York Times to publish it. So the precedent in the arena of the adult press is it's very, very difficult to censor in advance of publication. On the other hand, I also told you that there was kind of a double standard in this area, that the Supreme Court has ruled that the children's press is far more prone to censorship, and that the government has much wider censorship discretionary authority. And we see that in the last of the cases in your notes referring to prior restraint or censorship, the case of Hazelwood versus Kuhlmeyer. This is the Supreme Court case in which the Supreme Court ruled that the children's press has fewer rights than the adult press. This case came out of St. Louis, where students in their local high school newspaper wanted to publish several articles dealing with the impacts of topics of contemporary interest to students. These would be topics, for example, like teen pregnancy or the impact of parental divorce. The principal decided to delete these articles, not allow them to be published in the newspaper, and the students sued, saying that the government, in this case the principal, was engaged in censorship. Now, your notes just points out that the court ended up giving the principal wide censorship powers over their paper. And essentially, here was the reasoning of the court, and I don't have that in your notes, but if you want to add it on the side, you can. If you don't want to, it certainly isn't necessary. But the argument of the majority on the Supreme Court was that the newspaper is sponsored by the school, and therefore the school and the principal, as the governing principal in this particular matter, has a legitimate interest in preventing publishing articles that the school or the district deems inappropriate. The court majority went on to make the claim that unlike the adult press, which is a public forum, a high school newspaper is not a public forum, that it is a limited forum, and it's a limited forum for journalism students to write articles that are subject to editing for journalism students to meet the requirements of their Journalism 2 class. So there were multiple reasons for giving the high school students fewer press rights. One of the big ones was this notion of public versus private forum, and the second was the amount of authority that should be given to the principal in this case, and the Supreme Court majority gave the principal wide discretionary authority in this particular case, claiming that this was an extension of the school because the school was sponsoring this newspaper. In short, to summarize the notion of prior restraint, very, very difficult for government officials to censor the adult press. The children's press, the press below college age, there certainly is significantly more discretionary authority. The other issue that I have listed under freedom of the press deals with libel, and a lot of students misinterpret libel. A lot of people make the assumption that if something is false, if it's not true, that it's libel. And in fact, the courts have ruled that for it to be libel, uh, that it must be more than false. It must be knowingly false when published. There has to be malice. There has to be an intent to injure, and there has to be an intent to mislead the reader into believing the falsehood. And the very difficult standard for libel, and this is really what I want you to know about the first case, the case of the New York Times versus Sullivan. The Supreme Court in this case was dealing with a case where the New York Times published an advertisement. Mr. Sullivan had won a $500,000 judgment in lower courts. Essentially, there was an advertisement that was basically true in the New York Times, but there were some clear factual errors. And the Supreme Court in this case overturned the libel judgment, and the reasoning of the court was that the First Amendment protects newspapers, even when they print false statements, as long as the newspaper did not act with malice. And in this particular case, the reasoning of the court was the New York Times had no idea as to who Mr. Sullivan was. There was no intent by this newspaper to injure him. Certainly, the newspaper would be expected to print a retraction to inform the readers that there were these falsehoods in the newspaper. However, just a falsehood does not constitute malice. And so there were factual errors. The New York Times had to admit to these errors publicly, but they did not believe that just because there were errors that this constituted libel, because there was no malice in this case. What was intriguing was that this was a unanimous decision. It was a 9-0 decision. But remember when I talked earlier about how there are concurring opinions. Remember, a concurring opinion is an opinion where you agree with the decision, but you would use different legal reasoning. In this particular case, there were 3 justices who wanted to go even farther in this decision than the majority did. 3 of the justices wanted to create an absolute privilege for critics of official conduct, even if they were false. In other words, 3 of the justices were saying that freedom of the press in the libel area should be absolute if we're talking about the conduct of public officials. Now, that was a minority position. It was only 3 of the 9 justices. And so the more moderate opinion, setting that high-pronged standard that in order to be libel, the statement had to be false, it had to be knowingly false, there had to be malice or an intent to injure, and there had to be an intent to mislead the reader, was the majority opinion. But there were 3 justices who wanted to give even more protection to the press than that. And I used the second case, Falwell versus Hustler magazine, to kind of demonstrate this standard in action. The Hustler magazine and Larry Flint, who was the editor of the magazine, had run numerous parodies of the Reverend Falwell. Probably the most famous was a cartoon parody of the Reverend Falwell supposedly having sex with his mother in an outhouse while intoxicated. Hustler magazine also ran a famous spoof of the Campari, an Italian liqueur ad, essentially the same thing. Once again, alleging in this particular case incestuous relations in immoral drunken behavior by the Reverend Falwell and his mother in this particular case. The Reverend Falwell in lower court won a $150,000 judgment against Hustler magazine for these parodies of the Reverend Falwell. The case was then appealed to the Supreme Court. And as you can see in your notes, the Supreme Court unanimously, in this case an 8-0 margin, ruled that a parody of the Reverend Falwell having sex with his mother was not libel. There was not an attempt to mislead the reader into believing the falsehood. Also, the fact that the Reverend Falwell was perceived as being a public person, and therefore there was wide immunity from prosecution in this case of Hustler magazine. In essence, the argument was there was no malice, and that no reasonable reader of the magazine would in fact ever believe that the Reverend Falwell had engaged in this particular behavior with his mother. And so if you take a look at the New York Times versus Sullivan, and you take a look at Falwell versus Hustler magazine, what the Supreme Court has done in the arena of libel is that they have made it very, very difficult, especially for public people, to successfully sue for libel. E.B. Sullivan was the public commissioner for public affairs in Alabama and Birmingham, and he lost unanimously. The Reverend Jerry Falwell, although not a public official, the Reverend Jerry Falwell was the leader of one of America's most powerful interest groups, a group that called itself the Moral Majority. And as a result of that, essentially what the Supreme Court ruled was because the Reverend Falwell was a political figure, he was a very powerful lobbying dynamo in this case, heading this group, the Moral Majority. The Supreme Court ruled in this particular case that the Reverend Falwell wasn't just a reverend, he was a public official, he was very, very powerful, and therefore the press, in this case a magazine running spoofs in parodies of the Reverend Falwell, was in fact not libel and therefore allowed. So that's freedom of the press. When it comes to prior restraint, a double standard. On the one hand, the adult press is widely protected from censorship, the children's press isn't. In the arena of libel, the press is widely protected from lawsuits of public officials who are trying not to be criticized by the press. So in both of these areas, the press has wide latitude in terms of reporting events. The next area in the next tape that I'm going to go to is freedom of religion. And I want to say a few things about freedom of religion. First of all, in the colonial period, there were colonies that were established for religious reasons. For example, Maryland was established as a Catholic colony, and the fact that it was established as a Catholic colony led to some very interesting things in the state of Maryland. For example, until the early 1960s, there was a law on the book in the state of Maryland saying that you could be fired from your job if you were an atheist, and the Supreme Court only struck that down in 1961. When I talk about freedom of religion in the next tape or two, there are two distinct issues related to it. The first one that I'm going to get into is the Establishment Clause. So there often is this phrase, this wall of separation between church and state, but there is no mention of this anywhere in the Constitution. And when government is or is not promoting or inhibiting religion is at the center of this controversy, and it's a highly subjective area in terms of when the government may or may not be promoting religion. In recent years, the controversy that has come to fore is the notion of the Pledge of Allegiance, for example, and I'll talk about that later.